Hey everyone, and welcome to today's show on Wealth Strategy Secrets. Today we're joined by Kevin Day. Kevin Day is one of the leading estate planning and international asset protection planning attorneys in the United States. Mr. Day's bachelor's degree is in Chinese studies, and he holds both an MBA in international management and a JD degree. He was a university academic administrator for 8 years, a law professor at the doctorate level, and a law school dean of students before going into private practice. In addition to his legal expertise, Mr. Day brings his extensive business knowledge as an MBA into international business to his law practice. Mr. Day is also a regular speaker to professional and business groups on issues affecting business owners and high net worth individuals. His expertise in asset protection and estate planning brings him to be a noted speaker of continuing education conferences for legal professionals as well as accounting professionals. Attorney Day is also the co-author of 4 books: Lawsuits, Taxes and Asset Protection, Offshore Money Strategies, The Privacy Guide, and the Ultra Privacy Guide. And Attorney Day believes in giving back to the community through charitable and civil involvement. Kevin, welcome to the show.
Thank you, Dave. I've forgotten some of those accolades.
I know it's always a long bio and listening to it, speaking of yourself. But I mean, what's interesting is the Chinese studies. How did you start studying Chinese?
Oh my gosh. I was tired of Spanish, and UC, University of California, requires a couple of years of language, and I was involved in martial arts at the time, and I chose Chinese, and it just sucked me away. And
wow,
I had a political science minor, and went over and lived in China for a couple of years during my degree period. Yeah, really got into it and enjoyed it.
That's fantastic. I've traveled through Asia, and I've been learning Italian for the past 5 years, but Chinese is a whole new level.
Yeah, we don't have a basis for it. Most other languages have kind of filtered into our motley English, so we have at least a bearing. But I really enjoyed my time and really enjoy that culture.
Sure. So, yeah, maybe you can just shed a little light for folks who aren't familiar with you, a little bit more on your background and how you eventually got to, where you are today.
Yeah, I did cross-border contracts, maquiladora contracts with Panasonic and others. I'm here in the greater San Diego area, and I had a partner at the time who was a living trust guy, and we had somebody come with a very simple, and he's said we could use this example, this giant slingshot, and everybody's seen it with the 2 beach babes and the beach brawn pulling it back, and put balloons in here and never pointed at anybody, and never put rocks, and never shoot an egg at somebody's head. And of course, 3 or 4 times a year, people got hurt and suits arose. The US had signed the Hague Convention on Trusts a few years earlier, and that was revolutionary. And this is important for the listeners. Prior to us signing the Hague Convention on Trust, the only way you could get a lawsuit-proof trust was to give it away. Put up an irrevocable trust for your children. You would give it away, have no ownership or control, and you would have the bank trustee or someone being the trustee. And that's great if you have just way too much wealth. But most people, even very wealthy people, say, hey, I want my kids to get it after I die. But if me and my spouse want to go to Europe and blow $1 million in a year, I want to be able to just use my money. So those sorts of trusts, these children's trust, I'll call it, trust for children, only really happen when people are older and starting to do gift planning. But when the Hague Convention was signed, all these entrepreneurs immediately heard that other countries allow you to be the beneficiary under certain conditions, and that's an irrevocable trust. Because US signed the Hague Convention on Trusts, it became the law of our land. And effectively, we can have an irrevocable trust, which means you don't own it. You've got legal deniability of the assets that that trust owns. They're not pierceable, and it removes US court jurisdiction under US law. And they said, sign me up. And away went I started writing books and kind of I'd love to say that I was particularly brilliant, but it was just good timing. I got pushed up to the top of the heap. Arnold Goldstein out of Florida and I became the kind of continuing ed gurus throughout the United States.
Wow. That's excellent. So I'd really like to jump in. I think basically our listeners are going to get a ton of value out of this. And I believe that this space in terms of asset protection is something that people should be looking at proactively. And unfortunately, I think the reality is it probably happens more reactively when there is some type of event that causes people to really get caught off guard. And a lot of folks in our community are busy most of the time, raising families, building businesses, and focusing on really the capital creation side of things. But as you really start to build out wealth and start to become, ultra high net worth in these categories, preserving your wealth is absolutely key. And I think, being proactive about it is just, critical. So Kevin, what would you say really, just to kind of help frame this a little bit. And again, I think a lot of people are maybe newer to, the asset protection side and estate planning. So why don't we let's start 101. Can you explain a little bit like big picture around asset protection and estate planning?
Yes. And my firm, we have 28, and I think 4 more people are coming on over this next month. Our firm are estate planners. So we do charitable remainder trusts. We have a litigation department that does estate litigation, but we do all the basic wills and trusts as well. And these lawsuit protection trusts, or my department, lawsuit protection and privacy, they're not necessarily the same thing, but they're hand in glove. Lawsuit protection and privacy is really important. As you said, your business plan, your wealth plan, and what you've worked really hard for is only as good as what you've planned so that you can keep it if something happens. And lawsuit protection really boils down to a simple, what is seemingly simple concept of legal ownership. If you're on title, the court can take it to give to your creditor. And so if you own things, then it can be taken. If you don't, a lot of people go by the seat of their pants. Oh, my sister has a low lawsuit profile. She has no employees, no tenants. Let's put things in her name or a child's name. But then the child or the trusted person has a freak accident. So putting it in other people's name is just way too dangerous. It also has bad estate planning consequences. That's where these irrevocable trusts come in. It's really just changing ownership. And we now have, after the Hague Convention, we now have domestic trusts, which are much cheaper. You're still within the US court jurisdiction. The Hague Convention trusts remove US court jurisdiction, which is fantastic. But of somebody with a small shop or small investments, a W-2 employee that's just starting to get into single family residences, offshore probably is too big of a hammer. So there's less expensive domestic versions that are workable. And you had mentioned these transition trusts, sometimes referred to as bridge trusts, and they're as cheap as $10,000, and that's cheap insurance in any business owner's mind of getting something that really won't allow your estate to be invaded or taken.
Okay. So who do you think this is really for? Right. I mean, I think a lot of, certain people might think, hey, I need to have a net worth equal to X, before I get into this type of asset level protection. But what would you say to that?
Yeah, I used to avoid that question because it was a dollar amount for years. I mean, like 10 or 11 years, I just wouldn't answer it. But what I noticed is, when did my clients choose to go offshore versus when did they choose to stay domestic? Um, and also stating first, when most people, on business owners or wealthy W-2 people, go to a corporate lawyer, real estate lawyer, or estate planner and say, I want lawsuit protection, they go, oh, great. How many assets do you have? Oh, you need 7 LLCs, period. That's end of story. That there isn't any other things available under the law for lawsuit protection. And there's so much more. What they're saying is, we'll put eggs in different baskets. And if your CO2 carbon monoxide detector doesn't go off and you have a family of 4 that have died, you will lose that building that they were in to that lawsuit, because you're not going to have enough insurance. But at least it doesn't come and take your other assets, doesn't take your home. Well, we don't think that that's good enough planning. And we have strategies that can protect the equity within properties and so forth. So going back to your question, offshore, if you're 4 million and above in total assets, you should very seriously consider it. If you're 2 million and below, then the domestic asset protection. If you're between 2 and 4, we're really going to do an analysis on how much risk. Do you have super high risk, but you only have a 2.5 or $3 million estate? You have machines that can take people's arms off, things like that. How many, I hate to say it, how many teenage or, young adult drivers do you have driving your car and not owning their own cars? Things that can, and the more tenants you have. Or are you really on a rocket ship trajectory? You've made some really good home runs and you didn't own a home 3 years ago, and you've actually bought a home and upgraded your home, and you've got, X number of employees, or tenants. Why do domestic just to move it offshore in the future? That's absent, the 10, $11,000 kind of transition or bridge trust.
Sure.
But once you start to get tenants, a little coffee cart could have a bad evening. They don't have enough insurance to cover that. So is a $10,000 investment for a comprehensive lawsuit protection plan worth it? People that are W-2, if you get 1 or 2 single family residences, maybe you don't, you put it off a little bit longer, but you get more, or your wealth is larger because you're passive investing, you don't want that taken away, certainly by
Absolutely.
3 million and above.
Okay. Okay.
With passive, you don't have employees, you don't have tenants, but you're, starting to get up there at 3, you want something in place.
Yeah. Okay. No, that's helpful. And tell me if I'm wrong here, but the way I like to think about asset protection is, I really think of it in terms of layers. So kind of like an onion, right? Where you have at a basic level, you're going to probably have a will, created. You're going to have insurance, right, for your auto insurance. Then potentially next level up might be an umbrella insurance, right? That's, somewhat cheap that you can put around it. And then you start getting into these more sophisticated type of concepts, right, that you're talking about, like the bridge trust, right, and things like that, that seem to, be basically another layer that can insulate and protect your wealth. Is that a way to describe it, or how would you describe it?
No, absolutely. We get so many people that are so far down the track that they say, what do I need? And I really need a comprehensive package. But for those people starting out, you want a roadmap. You don't want to
Yes.
throw all your money in it. And, as you said earlier, this is kind of an orphan area of wealth, preserving your wealth. It's much more exciting going out and finding, an investment to put it in. But you're correct. A will, and then a trust, and a living trust, a revocable living trust, really is about 11 different documents to be a comprehensive estate plan. Then you're talking about a corporation. That fundamental lawsuit protection is putting eggs in different basket. The insurance, obviously, cash value insurance, doing infinite banking. But also, when you do that, you usually want an eyelet as well to protect the back side of that wealth. Not all states have protection over cash value, so you usually want an irrevocable life insurance trust. If you're doing a lawsuit protection plan, we can put the eyelet provisions in it, so you don't need two separate trusts. So it is a progression, and it's absolute layers. Absolutely.
Yeah. Okay. No, that's great. Yeah, we're very familiar with the infinite banking strategy, and we really have crafted an entire, I would say it's a comprehensive wealth strategy, because we like to look at wealth very holistically in our community, right? So it all starts with kind of having the right mindset, right? And then starting to look at some of these different asset classes that people can invest in that are outside what you're hearing from conventional wisdom. But as you start, building your wealth and getting into some of these opportunities, there's multiple layers of, like the infinite banking, where you've got your capital warehouse there. You do have that initial layer of asset protection that's built into that. But I just do think that I can't stress enough, really, the asset protection component, and how important it is to start building those layers as people build, their wealth strategies out. And we have everyone from entrepreneurs who are making exits in their business and selling their businesses, so they come into a large amount of capital from a liquidity event and need to put something in place quickly, to other people, that are still growing kind of incrementally, but they're on, a nice fast track, as you like to say. So I think, these layers are just really key for people as they start to build out their strategies. But help me understand and talk to the listeners about structures, right? So when I think about this, right, you have your CPA, for instance, okay, on your team, right? In fact, also talk about building a dream team, Kevin, right?
Oh,
So I would see, you as a key member on the dream team, right? You have a CPA, you have your infinite banking person, right? But the CPA is going to be talking about, okay, what are the tax dynamics, right, that we need to consider as you're on this wealth building journey. And in some cases, they might be talking about creating different entities. So a holding company, for instance, you might have a holding company that's going on here. You might want to create a trust from an asset standpoint. But help us understand, is there one strategy really that you would recommend that's really, say, the trust from kind of a top level down? Or how do you start really architecting, the right asset protection strategy?
yeah. We, although we do have tax attorneys on staff, I think we have 3 of them, but it's really in the formation of 501c private foundations and charitable trusts. We're not tax advisors, we're not CPAs. So we always want to work with the team. We want to work with the client CPA. And we have become skilled at creating a structure that, let's call it, disregarded for tax purposes. So even though we might be adding a lawsuit proof trust, whether it's offshore, domestic, a Nevada or Wyoming privacy company to be a holding company of wealth, we usually will create them as disregarded entities, so it doesn't mess with your plan. Clients usually come to us and they already have the loss carry forwards and profits balanced out. But working with your CPA, if they're saying, no, we really need this entity to be a C Corp because they're making too much money and we don't want two bites at the apple, we want it growing in there, they don't need that income for their lifestyle, then we make sure those types of entities are put in place. Yeah, but having a team that communicates is essential to our clients' success.
Yeah, absolutely. So also, can you talk to us a little bit about, we have a lot of investors who are investing in real estate syndications, other alternative assets on the private equity space. So can you talk to us briefly about the inherent asset protection you have as an LP at one level, and then what would be that next layer of asset protection you could get?
Yes. And it's not dissimilar to what my wife and I have gone through. We both are W-2, although I own my firm, but my income. And we got to the point, and this is where I think people, when they get to about 3 million, all their creature comforts are taken care of. They've upgraded their cars, they've done this, that, and the other. And then they go, I'm fine. What do I do with this extra cash? And then they often buy a single family residence, and we bought a bunch of those, and we didn't want to manage them. It was fun going out and finding them. And then we said, we need to invest in other people's projects because we don't have time for this. And then the syndications are the perfect answer on the limited partnership side. And we typically will have, with or without the lawsuit protection trust, we're usually going to lower the client's profile. So we're going to use a Nevada or Wyoming company where their name isn't in public record to be the holding company of zero liability or very low liability assets, cash portfolio, and limited partnership interests. It's very low liability there to the client. And that's what plaintiffs' attorneys are looking for. They want cash portfolio, limited partnership interests, notes. They don't want real estate. They don't want businesses. And so that's what we want to kind of hide. Whether we have that lawsuit, we've taken the next step to do a lawsuit protection trust or not. We want to have that holding company that has anonymity about it. Now, if you're making too much money, then you want to be on the general partnership side. You can get accelerated depreciation and so forth, but you're signing up for the liability as well. That's when you definitely want a lawsuit protection plan, so your exposure is minimized and most of your estate is protected.
Right. That makes sense. So would that be considered almost like a holding company, if you will, for this kind of trust? If this trust is, we just had a guest in last week. He's got over 57 different syndications, right? So would you roll those all up into this singular trust, or would there be multiple ones underneath?
We have some clients that have the need for two trusts, but one trust as a surrogate for you, but we can totally go to court and say the only way to attack an irrevocable trust here at home or internationally is for the plaintiff to allege fraudulent conveyance. Only way to unravel it. And that means you had a known existing current creditor when you set it up, and your intent was to not let them get your assets. Not that you have a dangerous business, not that you have, a dynamite manufacturing facility, or you have threshers or whatever it is, that you could have harm. If nobody's arm is blown off, or nobody's been, has a claim against you, then you can set these things up. So you want to set them up beforehand. And so that kind of lawsuit proof trust, our clients, entrepreneurs, don't want to be like a Kennedy grandchild where they have to go to the trustee and ask for things. So all we do is put a piece of paper of ownership in that trust. We have that underlying company for two reasons. One, as you said, a holding company to amass all those low liability assets, but also give the legal control back to the client. So they have the checkbook, they decide what they invest and when they pull the trigger and how much they get paid. So it's very entrepreneurial friendly. We have a second trust when you have something that is also very, very dangerous, but also the golden goose that's making the money. That's where we might have a two lawsuit proof trust structure. Uh, uh, just recently, good example, Elon Musk. About a year ago, he defamed some other billionaire, and he flippantly and said, go sue away. I don't own anything. And the only way to create non-ownership, companies are separate legal people from us, but they have to have an owner, right? So a corporation can be owned by an LLC that's owned by an LP that's owned by a corp. It will only end in two ultimate owners. There's only two ultimate owners in our legal system: a flesh and blood human, nobody owns us, and an irrevocable trust. That's why they are lawsuit proof. They aren't you. You're an ultimate owner, independent of you.
Interesting. So, and then explain the difference really between doing a domestic trust versus an offshore trust.
Yes. There's only about 15 states that have passed statutes, copycat laws of the Hague Convention trusts. And if you're in one of those, and of those, there's only about 7 that have any teeth to them. So even if you live in a state, that's good, but I would put you in a different state that has better law because of reciprocity at the US constitutional level. The US Constitution, fair faith and credits, says that we have to respect the law of other countries. That's why you can live in New York and have a Delaware company or a Nevada company or a South Dakota company. So you can also use trusts in different states. So if you live in a state that has a statute, they're going to more likely recognize a better state's law. But if you live in California or New York that has not had these copycat trust law and will probably never will, it's kind of a gray area because they're going to say, hey, we have this judgment here in New York. We want to bring this Nevada or Wyoming company and the trust that's in South Dakota or wherever we have it. We want you to come into our courts in New York and be subject to our laws. And they're going to say, because of the fair faith and credit between the states, you have to recognize our judgment here in New York. And of course, the counter to that is, well, because of fair faith and credit between the states, you have to recognize the law in Nevada. You have to come to Nevada and attack our trusts. There hasn't been any cases yet. And it's going to be a long time before there is. That's a conflict of laws, which means that kind of challenge goes to the Supreme Court. That takes 8 years and millions of dollars. And if there's going to be that kind of dispute, there's millions of dollars in the trust, and those people use offshore trusts. So I think the domestic trusts, even if you're in a state that does not have the statutory trust for lawsuit protection, they're still very, very strong. So if you're a smaller state and you want true lawsuit protection, the domestics are very, very viable and will be into the foreseeable future.
Everything you thought you knew about investing was wrong. Would you like to create a wealth strategy like the top 1% have and get exclusive access to top private equity deals that provide downside protection, tax efficiency, predictable cash flow, and have a lucrative upside? Discover how with the Pantheon Advantage and join our investor club today at pantheoninvest.com. The reason that you would want, say, an offshore trust versus a domestic trust is to, again, become, more bulletproof, right? You have that additional layer then of protection, would you say?
Yeah. They're recognized in all 50 states. The IRS recognize them. There's actually a form for them, essentially. It's called a 3520. For those of people that are audit shy, although we've been doing this, for 30 years. We've seen no incident of audit. If you have an offshore company and you're filing a TD90, you're going to get an audit every 5 or so years. They just want to, hey, we're watching you. We know you have an offshore company or an offshore account. But forming a trust and filing a 3520 has never triggered an audit. And that's really powerful, because as a piece of the defense file, if somebody sues you and brings you in and you have this offshore trust, the other side is going to say, hey, Your Honor, they're going to try to, play to non-legal issues. Oh, there must be something wrong. And we'll go, no, here's the law. And it's recognized on all 50 states. And by the way, Your Honor, here's our filing of a 3520. Judges are as frightened of the IRS as all the rest of us citizens. It's the nail in the coffin right there. It's very powerful. So you're not in any gray area. You're not just relying on me saying, hey, this works, trust me. This is something that's institutional and it's recognized by the government. It removes U.S. court jurisdiction. Someplace like Gibraltar has instant lawsuit protection under bankruptcy standards. Someplace like the Cook Islands has it actually has a drop dead statute of 2 years, but an effective statute of attacking it in 1 year. We could set it up today. You get sued tomorrow. We could drag the U.S. case past that statute, and it's going to remove U.S. jurisdiction. The U.S. lawyer isn't a barrister. They're not able to carry on the case internationally. Hate to say it, but attorneys are business people too, and they're going to be then pushed to the point of encouraging settlement. Some foreign jurisdictions, Montserrat and some others, Cook Islands, they require a cash bond from the plaintiff only to run the case. Huge impediment, even if they know about the trust and they're suing within that 1-year statute where they could bring it down there. So they're really, really powerful. Anybody in the right mind would want offshore except for the expense, and that's part of the equation. Yeah, that's why we have those transition trusts, or what you'd referred to bridge trust, is creating a domestic trust with provisions that allow it to move offshore if and when you want to, and that could be because of risk increases, wealth increases, or I just got served.
Okay. Interesting. So that process to transition it to offshore, is that fairly seamless?
Yes. And the provisions need to be there, because if the provisions aren't in there, the client, as the beneficiary, can get all their wealth back and then set up the offshore trust. Well, now you just started a new statute of limitations. But moving from one trust to offshore, that isn't a change of ownership. You're not back in the ownership chain. The other side will necessarily have to jump up and down and call fraudulent conveyance, because that's the only way to attack them. And we'll be able to say, no, the change of ownership that happened 2 years ago is when the transfer happened. The trust, look at Article 9, it always intended to go offshore, and it's not a change of ownership. Sorry, it's not a fraudulent conveyance.
Right. So I've actually had some experience on the offshore side. Talk to us a little bit about the complexities of that, as well as, administration and costs to that. Can those be significantly higher on the offshore side versus domestic?
Yes, on both the cost to set up and maintenance. We're full transparency. An offshore trust will be anywhere from $30,000, maybe up to 80. Rarely, our Cook Island Trust, Isle of Man Trust, is $30,000, period. Okay. Most of our competitors are in the $40,000, $50,000 range for a Cook Island Trust. The maintenance is going to be about $3,000 a year. That's the annual government registration fee and the trustee fees. Where a domestic trust is you can go to a bank trustee, but they're going to charge way too much for this structure because they really have no money under management, and we don't want them to have any money under management. We're entrepreneurs, and we are smart and educate ourselves to do better things with our money. We have trustees that are as low as $700 a year.
Okay. And so you
And that would
manage,
be the bridge trust too,
okay,
whether it's
yeah,
domestic or the
okay.
transfer trust.
And you guys can provide some of that administration support, so you're not having to, deal with some other, entity or other company.
Yeah, and that's the whole point of not having an active trust. The active trusts, like Carnation's and grandchildren, Carnation grandchildren, Kennedy grandchildren, have to go to the trustees because they have the money, they have the wealth. That's not the way we structure it. Rarely. We have a few clients that have needs for that or desires for that, but less than 1%. Everything is done at the underlying company level. And most of our clients, especially in the first 4 or 5 months of creating a structure, they're calling us every month saying, did I remember this right? Or I'm about to make another investment. Do I put it in my right pocket or left pocket? Do I put it in the lawsuit protection side, or do I put it in my name because of the risk? And that's regular dialogue that we have with them.
Got it. Got it. Okay. And help us understand as well. I think there's a lot of confusion out there when, as people start to build entities for whether it's a business or a real estate investment opportunity that they're looking at, but the laws between the states. So Nevada, Wyoming, and Delaware, people always, talk about Delaware, but I know I've been using Nevada and Wyoming, but as an expert here, please explain to the audience, which are the best states to use and for what purpose.
Yes. Delaware is seen by corporate America and business owners, even before they get into business. You have a little machine shop or something, Delaware is where the business companies come from. And it's really from what they did in Delaware and not in any other state, was they took the control. It's really for a public company. They can't have the owners, like me owning some IBM stock, wagging the dog. So they took the power away from the shareholders and gave it to the board. So unless you're going public, you really don't need a Delaware company. Even if your intent is to go public in the future, but you're not now, you probably don't want a Delaware company. Nevada, in its infinite wisdom, its precedent is Delaware. They took Delaware law and Delaware precedent, codified it, but gave the power back to the shareholder. So you have very good business law in Nevada. And you can have a Nevada company, and then you operate for 7 years, and you're in a position where you need or want to go public. Then we can do a merger and transfer it to a Delaware company for that process. There's a lot of administration in Delaware companies. We form them, but we usually recommend Nevada and Wyoming.
Right. And also in Wyoming, there are no chargebacks, correct?
Correct. Exactly. Also, some differences. Nevada requires an officer and director to be listed. You can hire nominee officers and directors, or you can use your sister or brother-in-law with different last names. Wyoming is much cheaper all in all for annual maintenance between RAs and annual registration fees, and they don't require a nominee. You can also hire nominees there, or put your brother-in-law, sister, somebody with a different last name on it. We actually like a name in the public record generally, because we don't want your plaintiff's attorney seeing some kind of transactions between Golden Mountain Lending of Wyoming, and they look it up to see if you're related. They see a name, it throws them off. They don't see a name, they actually don't think small business owners use sophisticated structures like this. So it usually blindsides them anyway, but lawyers being cautious creatures, if we can throw a name in it that's not
Yeah.
yours, it's good.
Yeah. Yeah. Now, you made a really good point earlier that I think that people don't think about as well, is that, in the legal world, right? I mean, lawyers are business people too, right? And I think from a creditor standpoint, right? If you don't have any of your layers of asset protection in place, the first place, and God forbid, right? Like you say, your teenager has an accident and a creditor comes after you. I mean, the first place they're going to look is your stock accounts, your cash, your house, things like that. But the more layers of this protection that you have around you, I mean, they're eventually going to give up, right? I mean, because it's not worth them fighting the chase if you can really build a fortress around your wealth.
Yeah, not only layers, we have another strategy that we haven't talked about, and that's equity stripping. So if we have this lawsuit protection trust, we have an underlying company, we'll often form it with a name to make it look like a hard money lender, Pine Tree Lending, golden triangle, funding or something like that. And we will create not just fake liens, but will create real consideration to put liens against the equity in your home, the equity in your rentals, put liens, UCC1 liens against your automobiles and your accounts, even accounts receivable if you own a business. So a contingency fee attorney, particularly car accident, you don't have to hit a school bus full of children to have a $20 million judgment. You can hit a family of four. Just recently, there was a single motorcycle accident, and the judgment was $65 million. Just
Wow.
crazy.
Wow.
And so a contingency fee attorney, they're going to be a business partner. They're not crusaders at all. And they're going to say, hey, this is a great case. I've gotten $4 or $5 million for this kind of case in the past regularly. Let me look into it. And they see, oh, yeah, you own a home and you own 5 properties. Your name is in the public record. You own, Joe's sandwich shop, you're shop owner. Oh, but it looks like you are highly leveraged to have all those businesses. Bank of America is on first and Golden Mountain Lending is on second. No, I'm not going to take this case. I just can't. They look like a turnip. Hourly attorneys, they'll take the $5,000 and then they'll do the research, and they'll take another $5,000 and they'll research, but they're going to come up with the same thing. They'll pound their chest in in the interactions, but they're behind the scenes telling the client, saying, yeah, Bill's Plumbing, he has 10 trucks driving out there, his name's all over the place, but there's UCC1s on it. He's living the American dream beyond his means. That's the picture we paint in the public record. And they're going to say, we better get whatever insurance they have. We're not going to be able to take anything else. And they're going to do that not only because they don't know our bizarre, this alternate wealth strategy that we have, as you said, but if they run a whole case and it costs their client $150,000 to run a case, and they say, here's the piece of paper, and oh, look at them, they're all encumbered, that's a formula for malpractice. So they will run it for a while, but they're looking for an early and low settlement. If you have a bunch of houses, even though you have layers, but it looks like there's a lot of equity, why settle early? Make you sweat. We might get another $1 million on the table.
Interesting. And what would you say, are family offices using a similar, type of architecture that you're talking about?
The family offices that we're involved with do, but it's not one of the normal, and I speak at a lot of family office conferences. But we also have high net worth people that are usually doing that sort of thing that bring us in, and some of the bigger houses that refer a bunch of clients to us because it's not in the normal org chart of the things that people care about and usually institute in family office. Lawsuit protection still isn't one of them, other than simple corporate formations to separate eggs into different baskets.
Right. Got it. Okay, excellent. That's been super helpful, Kevin. If you could just give one piece of advice to our listeners about how they could really accelerate their own wealth trajectories, what would it be?
Save. uh, if you live a little bit beyond your means, it's, give up a little bit now, you're going to reap so much more in the long run. I love the quote from Rockefeller in one of his last interviews. He was asked, "What's the formula to your success?" And everybody's heard this quote. They often don't know where it's from. Own nothing and control everything. And that's really a good adage. Privacy is your friend, even if you don't have lawsuit protection behind it. You don't have that ultimate owner of an irrevocable trust to the point where you can say under penalty of perjury, "No, I don't own Pine Tree Lending." Using privacy companies like Wyoming and Nevada, hiding your wealth is the first good step. You just don't want them, if they run all the way to judgment, coming in the back door. What do you own? You don't want to perjure yourself. That's a felony. That's lying to the court. It's not lying to the plaintiff's attorney. Then you say, "No, I don't own any real estate." Well, but I own this company that owns a bunch of real estate.
Right.
And but you can do it in stepping stone fashion. We have a road mapping process. It's $500 where we take in a client, we look at all their assets, we do diagramming so they can see what they have structurally, and then we'll have an ultimate plan and a couple of baby steps to build to it so that they kind of have a roadmap to where they want to go if they're doing it small pieces, not
Yeah,
pieces.
perfect. Now, I love that because, and that's why we talk about wealth as an overall strategy, because a lot of people look at it, I think, one dimensionally, right? And they're leaving themselves short because they're not taking into consideration all these pieces: asset protection, tax planning, right? Looking forward 25 years. I mean, all of those different types of things. So that's great that you guys provide that. How can listeners connect with you, Kevin? How can they reach out if they'd like to, set up an exploration call and learn more about, an asset protection strategy that might work for them?
Yes. Our phone number is 858-755-6672, 858-755-6672. And my email address is kevin@tresp.day.com. That's TRESP, as in Peter, DAY. Tresp, that's my partner, Elizabeth Tresp.com. And my main job is speaking. I will always make myself available, especially for the first meetings. But the head of our asset protection department, attorney Michelle Fishbein, actually runs that department and will ultimately do the implementation. I can always be called back in. I like the bigger picture strategy part, not the implementing.
Yeah.
So I want to warn everybody of that.
Yeah.
They're not surprised.
Spoken like a true entrepreneur. You have to understand your lane for sure. That's excellent, Kevin. We will also put a link in the show notes to all of that contact information. So people, if you're driving right now, we'll have a reference there so you can track down Kevin and his firm. It's been such a pleasure having you on the show, Kevin. I know I've learned a ton. I've been taking copious amounts of notes, and I want to go back and listen to this episode. I think multiple times here, but really appreciate you coming on the show today, sharing your experiences and your wisdom, and ultimately to really help our community to, build a fortress around their wealth and protect their family and everything that they're growing for.
Dave, thank you for having me on. And the fact that, because we've known each other for a few years, the fact that you're taking notes is illustrative that you do need to listen to this maybe once or twice. There's a lot of information there.
Awesome. Thanks so much, Kevin.
Thanks, Dave.